In competition law, one of the key questions is this: when should the law condemn a practice immediately, and when should it first examine the practice in context? That is the difference between the per se rule and the rule of reason. Under the per se rule, some restraints are treated as so predictably harmful that the authority does not need a detailed analysis of their actual effects. The idea is simple. Experience shows that this kind of conduct almost always harms competition. Under the rule of reason, by contrast, the authority looks at the market, the nature of the restraint, its purpose, and its real effects before deciding whether it is unlawful. As we learned in previous episodes, the classic source of the rule of reason is Standard Oil v. United States, decided in 1911. In that case, the U.S. Supreme Court said that the Sherman Act had to be applied in the light of reason. In simple terms, that means the law should not stop at the mere existence of a restraint. It should ask a deeper question. What does this conduct actually do to competition? This is also why the rule of reason can be seen as an early example of what we now call law and economics. The method resembles a balancing exercise. On one side, the possible anti-competitive effects. On the other, the possible competitive benefits or efficiencies. By later economic analogy, this resembles Kaldor-Hicks efficiency. A practice may be tolerated if its gains outweigh its harms. In the European Union, the American labels are not used in exactly the same way, but the logic is similar. Article 101 of the Treaty on the Functioning of the European Union prohibits agreements that have as their object or effect the restriction of competition. But Article 101, paragraph 3, allows an exception where the agreement creates efficiencies, benefits consumers, is indispensable, and does not eliminate competition. Under Article 102, EU law does not prohibit dominance as such, but the abuse of a dominant position, again with a more contextual and effects-based approach. In Colombia, the expression rule of reason has not always been used in the exact American sense, but Colombian competition law has developed a similar doctrinal interpretation. The emphasis is increasingly on context, effects, and efficiencies, especially in vertical restraints. That is why the CASYP case is important. CASYP was an airport concessionaire. In that case, the SIC examined a possible vertical agreement and ultimately found that the agreement had not been proven. Even so, the case is useful because it reflects a more economic and contextual method of analysis, rather than a purely automatic one. So the difference is simple. The per se rule says, this conduct is almost always harmful. The rule of reason says, look carefully, weigh the effects, and then decide. And that tension remains at the heart of modern competition law.